He now, though, has 6 days to appeal this to the Supreme Court. How would you expect that the high court would handle this matter?
Well, this is a historic opinion that was issued today, and it was a resounding rejection of Trump's claim of immunity from criminal prosecution. It's an extremely well-written, thorough, well-reasoned opinion, and it speaks unanimously on behalf of a panel that included one Republican-appointed judge, speaking in one clear, calm voice and holding that the former president is not above the law. The fact that it is such a well-reasoned and well-written opinion suggests to me that the Supreme Court might consider not taking up the issue. This is a thorough opinion that addresses every single one of the arguments that former President Trump had raised. And I don't see any reason why the Supreme Court would necessarily take up this case, except for the fact that it is such a historic matter, the first ruling ever by an appellate court on a former president's claim of immunity from criminal prosecution. And because of the significance of the issue, that is probably the best reason for the court to strongly consider taking up the case.
Wow. All right. So that's important, Jessica. If the Supreme Court does not take up this case, what does that mean for timing potentially of a trial? We had this on the docket for the beginning of March. Where would it then land?
So it all depends on how quickly the U.S. Supreme Court decides whether it's going to take the case or not. Mm-hmm. If it just decides immediately upon receiving the former president's application, which we expect he will file on Monday, then it would go immediately back to the trial court to set a new trial date. That trial date had been March 4th, but there are still about 3 months left in the calendar that the trial judge had set for pretrial motions to be considered. And so if the court were to sort of restart the matter immediately, say at the end of February, then we'd be looking at a trial that would be starting probably in the beginning of June.
Okay, so that potentially could be before the Republican convention and well before the election in November, which we know, depending on whether or not Trump is convicted of a felony by that point, it could change the way a lot of voters make their decision, which is why we keep this timeline in mind. Just to go, though, to the argument that the former president has made, he suggests that essentially this sets bad precedent because it means that whoever is in the Oval Office, as soon as they leave, the opposition party is going to indict them, going to go after them, going to try to prosecute them. Do you not share any of those concerns about precedent here?
So one of the arguments that he made is that this would essentially open the floodgates to prosecution by political opponents as soon as a president left office. And I do think that that is probably the most serious concern here. But that said, what the D.C. Circuit said is that they haven't seen any history of that happen. This is the first time that we've had a prosecution brought of a former president, and that there are checks in place to ensure that prosecutors don't bring charges that are unfounded. They talked about, for example, the ethical rules that bind prosecutors, so they can't bring a case that is not founded or that is based on political motivations. There's also the check provided by a grand jury of ordinary citizens who have to hear the preliminary evidence in a case and decide whether there's probable cause to go forward and issue an indictment. And so those are the kinds of checks on prosecutors bringing criminal charges that don't exist with respect to civil lawsuits brought by private litigants. Now, previously, the U.S. Supreme Court has recognized a doctrine of immunity for presidents for official acts committed in office against civil suits brought against them for official acts taken in office. And one of the concerns that the Supreme Court cited in recognizing immunity from civil lawsuits was this prospect of essentially floodgates of civil litigation. And what the D.C. Circuit said here is that we just don't see that same prospect with respect to criminal prosecutions.
Mm-hmm. It's believed with this ruling today, at least by many, you can tell us if you agree, that it's possible if this trial is delayed and as we wait for a Supreme Court ruling or a higher appellate court, that Alvin Bragg's case, the hush money case, could actually be the first to be tried against Donald Trump this year. And a lot of folks have gone out of their way to try to delegitimize that particular case. I spoke about it with Nick Ackerman today, who's a former assistant U.S. attorney. He was a former Watergate prosecutor, and he strongly disagreed with that characterization. I'd love for you to listen to what he said and have you respond.
What this case has to do with is Donald Trump defrauding the U.S. voting public in 2016. What he did was he engaged in a scheme that involved not just himself, but David Pecker at the National Enquirer and others, including his own attorney. This situation, if it had been released prior to the election, probably would have resulted in Hillary Clinton being elected.
It's a pretty strong statement. Jessica Roth, I wonder if you agree with it, and if indeed that might be the first trial to be had now.
Well, depending on what happens with how quickly the U.S. Supreme Court decides whether or not to take up Trump's appeal of the D.C. Circuit opinion, it may well be that the Manhattan District Attorney case will be the first one to go to trial. There are, however, remaining legal issues to be adjudicated in that case that could push that one over as well while the courts decide those novel questions. There's no question that in comparison to the cases brought by the special counsel, particularly the January 6th case that was the subject of this D.C. Circuit opinion, the charges of the Manhattan District Attorney's case are less serious. They don't involve a direct threat to democracy and overturning the results of an election in 2020. But they are significant charges, and they do date back to the 2016 election. They involve allegations that the former president falsified business records at the Trump organization to cover up payments that were made in order to keep a former mistress silent about their affair. And the allegation is that the former president concealed those payments in his business records in order to increase his chances of being elected on the theory that if the public knew about the affair, they would be less likely to vote for him. Those are significant charges, and we need to wait and see how the evidence unfolds in terms of who the witnesses are that the district attorney's office will put forward to support those allegations to ultimately make a decision on the strength of the evidence in that case.